Hello, 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 hello.
The appeal and lordship.
Yes.
Lordship, the matter may be passed over today and
How much time?
10 days, your lordship.
Do you have any objection, Mr. Kale? No. And counsel for the appellant has circulated an adjournment slip. Mr. Kale, when counsel presenting the respondents does not object, list up to 4 weeks. Much.
May please, your lordship. My lord, with the consent of the other side, my lord, item 22, my lord.
Yes.
My lord, my senior, Mr. Bisidas, is not well, my lord.
Okay. A request is made to adjourn the matter on behalf of the appellant.
Appeal.
List after any objection to the others for the other side. List up 4 weeks. Yes.
Lordship, with the consent of the other side, I beg to mention item number 23 and 24, your lordship. The engaged counsel is out of station.
We are for the respondents,
For the appellant, your lordship.
appellant, counsel for the appellant. Please for time. The other side has been informed.
I'm
Yes,
the respondent, madam.
You don't have any objections, sir?
I'm not maybe in the month of
April.
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 Re-notified for hearing in the 4th week of April.
Lordship is fixing a date. Lordship is
4th week, it will come up in the 4th week.
appellation.
May I please, your lordship, for item number 21,
Yes.
we need time to file an additional affidavit to bring on record an order passed by the Deputy Commissioner of Taxes.
When was the order passed, madam? This is a petition of,
Received, we have received recently from the opposite side, a
okay.
copy of the
Very
same. We need
Counsel
to-
for the petitioner, appellant, petitioner, prays for time to bring certain additional facts on record. Time to wait for is allowed, list up 4 weeks.
Thank you.
Okay. Do we need to call out even this page? There is an adjournment slip in each and every hearing matter. Right from 24 to 39. So we need to show this document to Mr. K. N. Chaudhary. All right. We'll not take up these matters. Everyone has circulated an adjournment slip. If any of the other side has an objection, please point it out to the court master. Need not mention. 27 and 30. If they are called out, we will take it up. No issues.
Beg your pardon, Lordship. Lordship, in item number 31 to 33, Lordship,
Yes.
I'm being represented by an outstation counsel. As such, a date may be fixed, Lordship, on 2nd of May, your Lordship.
Okay. Second maker then date.
Obliged, Lordship.
May I please?
Yes, Mr. Nayak.
My lord, there was a sumoto case registered by this honorable court pertaining to the issues between the judicial officers and the AG. That matter was considered and a way was worked out. But it seems, my lord, now they have filed an additional affidavit. It came to my notice. I'm bringing it to my lord's notice. That
Who has
still
filed? Who has
the association has
Okay.
filed an IA, my lord,
Okay.
for revival of that that sumoto case.
Okay.
Because, my lord, it's around 3 months now that they have been given a revision. The pay slips have not been issued till now. Now, my lord, month of March goes, it will
Can't-
take another 2 months, my lord.
Can't you simply talk to the AG rather than,
My lord, I had, on the earlier occasion, we had sittings, my lord, I personally was involved, and
Okay.
they had assured that everything, but now it seems, my lord, if it comes up, maybe a push, my lord, may work out, my lord.
Monday,
My lord, can it be Monday, my lord? Or Tuesday, my lord?
Tuesday?
Tuesday.
Tuesday.
Much obliged.
May it please your lordship. My lord, I'm praying for listing of this matter, my lord, for motion, my lord. In this matter, my lord, we have challenged the constitutional validity of the Assam Engineering Service Recruitment Board, my lord.
Mhm.
By framing this regulation board, my lord, the state government sought to appoint and select, my lord, the persons in the post of associate assistant professor in government engineering colleges. But, my lord, there is already a rule, my lord. 1981 rules governing all these conditions, my lord.
Okay.
So we have, and pursuant to framing of this board regulation, my lord, they have issued advertisement. My lord.
Mhm.
So, my lord, we have challenged the constitutional validity of this regulation.
Wednesday would be fine.
Can you come Monday, my lord?
All right, listed on Monday.
I am obliged.
Monday. Very well. Yes,
May please, your lordship. For that item number 44 in the supplementary list, my lord, it's a heard matter.
yes.
I'm appearing on behalf of Mr. S. Dr. Malad. He's suffering from severe throat infection today. If your lordship accommodates on Monday, my lord,
Oh.
just for the day, my lord,
I know.
I've informed them, my lord.
Adjournment on medical ground, other, I
Of
cannot
course,
object.
of course.
But since there is some urgency on my part, I'm being
On
deprived
Monday,
of
my
my
lord.
pensionary benefit. Lord, she will kindly take up on Monday, my lord.
Monday, my lord.
Tuesday,
Obliged. Deeply.
as paid. When request is made to adjourn the matter on behalf of then counsel
For the appellant, my lord.
for the appellant who is reportedly unwell, re-notify. Please for further hearing on 21st March.
Highly obliged, my lord.
May please, your lordship. I'm bringing for listing of an application for stay vacating, my lord. This is a surface side matter, my lord. There is a stay since June 2022.
So why is there supposed to be, you are appearing on behalf of the,
I'm
Bank.
the bank, my lord.
so after 14 days, the stay is automatically vacated.
My lord,
Why do you need a permission to get it listed?
uh,
The other side should have the urgency.
What has happened is that we have approached the deputy commissioner has passed an order for physical
You
position.
don't know, 2263, there's an automatic vacation of stay if it is not got listed by the party having the stay
That is
within next 14 days.
So the difficulty is that the office of the deputy commissioner will not carry out the physical position, my lord, if the matter is pending.
All right, 23rd.
May I please, lordship?
Yes,
Lordship, I'd like to mention item number 25 of today's daily list, lordship.
25.
Yes,
We'll
lordship.
not call out the hearing matters, don't worry. Every matter is sought to be adjourned. Okay,
May it please your lordship. Your
Yes.
lordship, in item number 50 and 52, lordship, we have filed an affidavit in opposition, lordship.
yes.
That may kindly be called for your lordship.
You want it to be taken up today,
Lordship,
50 and
52, your lordship.
hearing matters.
Lordship.
All right. When counsel, Mr. So-and-so submits that he has filed affidavit in opposition, the registry is that to tag the same with the record. You're talking of 50 and 52,
Lordship, the matter is fixed to the lordship. Lordship may kindly call for the affidavit in
but
opposition.
then there is a bunch. These are not the individual matters. It start from 45 and
Lordship,
go on till 54.
lordship,
So you file affidavit only in two
only into your lordship. We have private respondents in that.
private respondents. Okay, very well. Call for the affidavits.
May I please, your lordship?
Yes,
I'd like to mention on item number 36 of the daily list, your honor, with
yes.
the consent of the other side, your honor.
All right,
The
adjourn.
conducting council has gone to Delhi for his father's treatment.
Okay, very well.
May please, the lordship. May please, the lordship. Actually, I'm for the item number 34 and 35. And we have already filed an adjournment request. your
Yes.
lordship. Whereas because the earlier allotment council is no longer representing the particular matter. And as such, sometimes is required to engage another senior counsel, your lordship. So as the
Very well.
matter may be taken.
You are presenting the
The Bharti Airtel.
Okay.
Case, your lordship.
and council MS so-and-so submits that's time, the fresh engagement has been made, has to be made for representing the company in this, these two, in this appeal. And thus, some time may be, accommodation may be granted for doing the needful. List of 4 weeks.
Your lordship.
Lordship, I beg to mention a rate appeal for listing on next Monday.
What is the matter about, sir?
Lordship, matter pertains to selection and appointment of madrasa TET qualified candidates.
Okay,
And an advertisement had been issued.
what is the date of the SB order?
28 to 23.
28/2. So, all right, get it listed on Wednesday.
Okay.
Yes. We need not call, no point. After 4 weeks. Adjournment.
Item number 40 of supplementary list for motion.
May I please, lordship?
Yes,
My lord, the petitioner has applied for the post of postgraduate teacher in zoology subject under the director of second edition, my lord. And what happened, my lord, she is having the master degree in microbiology, allied subjects of the life science department, my lord. And In respect of biotechnology, there is provision in state of Assam, my lord. They have provided both zoology discipline and botany discipline to apply for the those zoology and botany post, my lord.
Okay.
My lord, this honorable court also interfered annexure 12A, my lord, earlier set of candidates belonging to the biotechnology group has preferred a writ petition, my lord. It's page number 10.
So you basically want a direction of equivalence.
Yes, equalization. And at this stage, my lord, I am praying for, my lord, allow me to participate in the verification process, which is going on, my lord. And appointment, if I, in the event I'm selected, subject to the outcome of the writ petition, that will do, my lord.
What is this earlier SB order you have in next page 88?
Yes, lordship, in the similar circumstances, single bench in respect of other cases, my lord, directed to the government to place the issue before the expert committee, and expert committee, my lord, thereafter decided in respect of biotechnology subject, my lord. Annexure 10 is the minutes of the, my lord, expert committee in respect of biology, biotechnology, botany.
Okay.
Having the botany, and thereafter annexure 12B, your lordship will find at page 10110, where in respect of zoology, the government has also zoology, but with my biotechnology master degree, they have taken the decision, my lord. But it ought to have been taken in respect of the other allied subjects. There are nine or 10 allied subjects, my lord. In central government, they take all the subjects into account, my lord, while filling up the post of PGT zoology and botany. But in state, it is not happened, my lord. So this petitioner, humble petition is before your lordship, my lord.
What do you say, sir?
At this stage, my lord, I'll pray for an instruction, my lord, whether
Okay.
this can be.
When is the process starting
Tomorrow is the last day for verification.
for verification?
Provisionally, if it's allowed, my lord, it's okay. My lord,
All right.
that would be subject to the outcome of the.
The petitioners herein are
Single petitioner, my lord.
the petitioner herein has qualification of
Master degree in microbiology
master's degree in microbiology.
with
He is
BSc zoology major.
with BSc zoology. He takes a claim for selection as a
A subject teacher,
subject
postgraduate
teacher
public postgraduate teacher.
in pursuance of the she kar dijiyega, it's a lady. In pursuance of the recruitment notification
Dated by 27/12/2022.
dated 27/12/2022. First up, it is stated that the degree being held by the petitioner is not being treated as equivalent to the degree of masters in botany or masters in science.
Yes, lord.
In science, even though, pursuant to an earlier round of litigation, the persons having degrees in botany and zoology have been placed at equivalence with the
Biotechnology.
MSc in biotechnology. And counsel representing the respondents please for time to complete his instructions. The verification process for the selections in question is closing tomorrow, that is 17th of March 2023. In view of the peculiar facts noted above, without creating any equities in favor of petitioner, it is hereby directed that she shall be allowed to participate in the ongoing selection process. However, the result of the petitioner shall be kept in the seal cover and will not be declared save with the permission of the court.
Highly obliged.
The respondents may file counter affidavit within next 3 weeks.
Obliged.
Item number 2 of daily list for admission.
May I please notice, my lord, in this case, my lord, the single judge has not considered, my lord, my prayer regarding, my lord, for direction, my lord, to respond number 2,
Yes.
under, my lord, FR 54B.
This was a contractual appointment, sir,
Yes, my lord. Yes,
for a period of 5 years.
yes, my lord.
In the meantime, you are found involved in a criminal case.
Yes, my lord.
How can the service be continued?
My lord,
You have been given a fresh contract.
that is done, my lord.
So how the continuity is permissible?
My lord, my lord, kindly see
Yes.
FR 54B, my lord, B1A. In this case, in
Page,
this, my
page
lord,
number.
my lord, it is not in the book.
Give it. Yes. Rule number
54B1A, my lord.
54B1A.
Yes,
Okay.
when a government servant who has been suspended is reinstated, my lord, in this case.
Is it a case of a government servant? Please let us know first. It's a case of contractual appointment. How does your client qualify within the definition of a government servant? You got your own answer? Okay. It's a contractual appointment, plain and simple. It was for a tenure of 5 years. In the meantime, your client was found involved in a criminal case. The contract was never continued. It is a fresh contract which has been executed.
It was executed, my lord.
So how do you get the rights under the old contract?
My lord, I have been reinstated, my lord.
It is not a reinstatement. Let us see the order. Is it a reinstatement? Let us see.
Yes, my lord. Page
See,
44,
Read.
my lord.
read, page 44. Yes,
And therefore, the undersigned, after careful consideration of the honorable court's order dated so and so, first in the WPC number 495517, order 6/10/16 passed by learned additional CJM, Moriga in connection with PS number GR number so and so, representation so and so, submitted by Jayanta
Yes.
Kumar Kumar, and exact rules on the given subject as discussed in the foregoing paragraphs,
yes,
and consciously decided to vacate the suspension order
yes,
seem to have been made on
yes.
19/3/16, accordingly allow Sri Jayanta Kumar Kumar to officiate his duties as assistant teacher, Pasim Kopili Valley.
So where is the requirement of agreement,
The date
of
of-
fresh contract being
Yes,
executed?
thereafter,
Where is the requirement? If he is a public servant and his suspension has been revoked and he continues in service, where is the requirement of a fresh contract? Let us know. Okay, thank you.
My lord, can I maybe allowed to withdraw, my lord?
Withdraw, very well. Honorable acquittal. Okay, after arguing the matter for some time, come on. Then counsel for the appellant craves liberty to withdraw the instant appeal. Hence, the same is disposed of as withdrawn.
My lord, liberty also.
Liberty of what? He is not in custody, so he is
Yes.
in liberty. Okay, very well. Thank you. Liberty of what? Another round of litigation. Sorry, we don't allow. We can put this to finality right now, if you want it. It's a contractual appointment. There's no question. Okay, thank you.
Item numbers 3 to 5.
शुद्ध हिंदी में कहते हैं काम के बदले अनाज. जितना काम किया उतना अनाज मिलेगा. बस.
Oblige.
I just discussed with my learned friend, my lord. Before troubling your lordship, I told him, why not go for a mediation for this case? Because this is an employee, two writ petition was filed by us.
Yes.
Two writ petition before the learned single judge.
Yes.
One writ petition was filed on the ground that the labor commissioner has forwarded
Yes.
to the certificate officer.
Mr. Das, in any event, it was required to be sent to the
Yes,
industrial
that's-
terminal.
That's why. It has, that's why I have come There is nothing I regret with the order of the learned single. Let us be very honest to it. Only is that we were not able to pay that 25 lakhs which was put before by the learned. So we came up division bench. The learned division bench said, okay, you have to pay 15 lakhs. So we paid 15 lakhs by way of fixed deposit. But another case.
We are rather talking in your favor, sir.
Yes.
This dispute could not have been taken up by the labor commissioner
Yes.
in the manner it was
Yes.
done.
Yes.
Oh, all right, you are for the union.
No,
I am for the union.
No,
You are for the union. This had to go to the labor commissioner, to the industrial tribunal. Couldn't have been taken. How the payment direction to make the payment, assuming that the labor commissioner had jurisdiction, he could only have acted as per 17(2),
Yes, correct.
having been subdelegated the powers by the state. So assuming the application was to the state, what was the courts open for the state? To refer the dispute to the industrial tribunal. So how could the labor tribunal, this labor commissioner undertake the exercise to straight off decide the liability and direct payment?
My case before the Honorable Single Judge was this, Your Lordship, that since although Your Lordship, a claim petition is made by us, Your Lordship, at no point of time, Your Lordship, they raise a dispute, Your Lordship. Until and unless if Your Lordship.
Irrespective thereof,
No, Your
they disputed the quantification.
No, Your
Moment
Lordship,
that was done.
Lordship, that was done for the first time before by filing the writ petition. Your
All right, the
Lordship.
labor
Prior to that,
commissioner, where are the proceedings before the labor commissioner? Let us see.
Lordship,
Yes. They simply said that, yes, we are bound by the Majiti award.
Lordship.
That is all. But how
Your-
the quantification is to be arrived at?
Your Lordship will kindly come to page 10, page 140, page 40, Your Lordship.
Yes. So tell us, how would the claim be quantified? What is the mode with the labor
Lordship,
commissioner?
the-
Simply what you claim has to be awarded?
No, Your Lordship.
Then
Your Lordship, what is to be done by the management, Your Lordship, they will have to
Yes.
dispute it, Your Lordship.
let us see page 40 you are talking of.
Lordship. I
Let
will
us see.
show only 3 documents, Your Lordship.
Page 40.
40, Your Lordship.
Just hold on.
It open up 347. Oh, they moved. This is in writ appeal number 347, Your Lordship.
Yes, we are having 347.
Lordship,
Yes.
page 40. I am enclosing here with a statement of arrear salary as per the recommendation of the Mazithia West Board of Employees appointed as working journalists, including the administration.
Okay, so it's straight of a direction to pay.
Then Your Lordship will kindly come to page. Your Lordship.
Just hold on. Before this, there's a document at page number 39.
Lord.
What is that?
This is Your Lordship on Your Lordship non-implementation of award of the Mazithia West Board by the different newspaper groups, Your Lordship, that is. But my case,
This is addressed to whom?
this was
The labor commissioner,
Lordship.
before whom the
That
proceedings
is
were
by
taken.
by the Your Lordship, by the union, Your Lordship.
So read clause 3 of this document.
Lordship. This is Your Lordship.
And even
prior to this, Your Lordship will
before-
kindly see this. then-
Before that,
Lordship.
come to page, annexure 1, page 16.
Lordship.
This is a notice issued by the labor inspector,
Lordship,
not the commissioner.
Lordship.
So where are the proceedings of the labor commissioner we want to
Lordship,
see?
This is not on the basis of our claim, Your Lordship. The letter that has been issued as on the basis of our claim, Your Lordship, that is at page 40. This is the first communication, Your Lordship.
Okay, page
They were
40.
put to notice, Your Lordship, by this, Your Lordship. Then Your Lordship will kindly come to page 46.
Yes.
46. Lordship.
Why not page 41?
Lordship, before that, Your Lordship, 46, page 94, Your Lordship.
Page 94.
94. This
Yes.
is Your Lordship dated 24/2017.
Oh, this is Majitia committee. We are not,
Lordship.
just hold on. Firstly, we are about the legality of proceedings before the commissioner. Let us see those proceedings.
No, your lordship, so far as the proceeding before the commissioner is concerned, your lordship,
Sir, we may make an absolutely absurd query, but you have to reply.
lordship.
So we are asking you, where are the proceedings of the commissioner
No,
point?
your lordship, the moment we submitted a claim, your lordship, and it was sent to them, your lordship, the management, your lordship, it is their duty to point out that we are disputing this claim.
So
Your
that is why we are asking you, where are the proceedings of
No,
the
your
commissioner?
lordship, that is, they did not object to that, your lordship. That's the problem, your lordship. Until and unless a dispute is raised, your lordship, and
How do we verify that the dispute was raised or not?
because
Where are the proceedings of the commissioner, sir?
that will have to be before the authorities, your lordship, labor commissioner.
Where are the proceedings of the commissioner? We want to see,
Well, that your lordship, from the record, your lordship can verify. I am representing.
is there any ground, Mr. Das, in your writ petition
Yes.
that the labor commissioner that you raised a counter objection in the proceedings and that thereafter the claim was proceeded? Let us see those. What's your pleading in the writ petition?
No, our case. Yes, my writ petition, my.
Yes,
Your lordship is taking my writ petition.
347.
Writ appeal, no, writ appeal is his writ appeal. My writ appeal is.
I have.
Kuntu.
No, this is your writ appeal. 347
347 is my.
is your appeal
Yes.
with a prayer for
Your lordship, we want that since this certificate has already been issued, this should be implemented. That is, your lordship. To that extent, I have challenged the order of the honorable.
Okay. Where's the writ appeal of the respondents? Of the
My lord, my writ petition, writ appeal 76.
76.
Paragraph 8 at page 23.
23.
My writ petition before the learned single judge.
Paragraph 8.
May I just read, my lord?
Yes.
It is stated herein that on 10/11, the Assistant Labour Commission response fee, White Company Director petition to pay the arrear wages of employees in accordance with recommendation of Majida Wage Board, enclosure annexed with state communication in a period. The petitioner was also asked to submit comply. It is specifically stated here, neither any enclosure of area salary were annexed with the state communication nor such statement of area salary was ever furnished to petitioner by responsible authority. My lord, we told before the learned single judge, as your lordship has said, where is that proceeding? We also want to know, because my lord, in 17(1), if any application is to be filed, there has to be a subjective satisfaction. Notice has to be given.
Yes.
There is a procedure which has been laid down on a 36(1), which has not been followed. We told, please produce the record to show where is our object. Then they could not, my lord. I think that was not produced, not my learned friend, by the department.
Yes.
Department. That's what
Where's
your
the
lordship is asking.
record of the labor commissioner? Please call for it. Madam Government Council, record of the labor commissioner. Government Council, MS so and so, shall keep the original record of the labor commissioner available for the court's perusal on the next date of hearing. Listing, re-notify on April 10th.
Item number 6.
Yes.
May I proceed?
Yes, please.
My lord, in this case, honorable court direction to bring instruction.
Lordship, I just pray for a further 2 weeks' time, Lordship.
Okay. Then Government Council, MS M. Bhattacharjee, praise for and is granted for further time of 2 weeks to complete our instructions or the direction given on so and so. Last date. 24/2/2023. Let's up 2 weeks.
Deeply aware.
Item number 7.
Yes.
May it please your lordship, here I'm aggrieved by the learned single judge's order whereby my writ petition was dismissed.
Yes.
What had happened was that lordship on 24/10/2014, I was given a letter of intent for for LPG godown. I was to set up thereafter.
That site was located in a residential area. You did not get the permission to construct. Thereafter, you leased out a plot which is at a distance of more than 15 kilometers.
According to me, it's less than 15.
So that is a disputed question of fact.
Which has to be decided by the authorities, not before by this honorable court. That lordship I'm quite aware of. Now, what has happened, lordship? The first they cancelled my order, my letter of intent. I came to the High Court, to this honorable court. Then this honorable court passed a judgment saying that that's at page 82, lordship.
Yes.
And with page 82.
Yes, please.
Relevant page is page 83, lordship.
Yes.
So that consequently, we set aside the impugned letter dated 5/3/2018 and directed the respondents to consider the representation of the petitioner dated 12/1/2018 and thereafter take appropriate decision in accordance with law within period of 4 weeks. This is what was given. Thereafter, lordship, my letter was already there before them. They cancelled this order, lordship.
Cancel your allotment.
Yes. Without on the same set of grounds. Lordship.
Yes.
Note, that was on 21/8/18, which is at page 88.
Madam, whether the allotment guidelines, do they allow for the applicant to change the location once the LOI has been issued? Please point it out.
Lordship, when the LOI was issued, I was to arrange for a plot of land. My plot of land was not there.
Your location must have been given in your application. Can't be.
Within that location, I was to arrange a plot of land, not a specific. Because at that point of time, even the authorities were aware I didn't have a plot of land. I was to arrange for it.
Well, ma'am, we are not very sure of this.
Because they have.
Anyhow, carry on, please.
They permitted me to do so.
Okay.
They permitted me to do so because when I asked them on 31/7/2017,
yes,
which lordship will find at page 59. We are pleased to inform you that your request at page 59 in Lecture 4.
Yes.
Lordship, will look at the second paragraph. We are pleased to inform you that your request to consider alternative suitable land for godown has been considered as per policy on the ground of restriction from the state body.
Statutory body.
Statutory body, in this case, from GMDA. So please arrange alternative suitable plot of land within the period of 2 months from the date of issuance of this letter, subject to the same meeting the specifications of construction of LPG godown as prescribed by the Indian Oil Corporation. So they did permit.
Meeting the specifications.
Right. Specifically, one of the specifications within 15 miles, 15 kilometers, and then second specification that it must be open from all sides, motorable road, etc., etc.
Right.
Those specifications are there.
Mm.
So I am to obtain this, and accordingly I did. And as per my GPS, which I have tried to show from the GPS, it is within 15 kilometers.
As the crow flies.
As a
Can't be. It has to be the on-road distance.
On-road distance, lordship, there are many roads to go to that.
So you point out the shortest road. Whether it is 15 kilometers or not, whether this court would decide.
Lordship, I would.
You're not taking a chopper for transporting cylinders, we presume.
Lordship, I must be given the hearing to do that. I should have been heard on that matter. And Lordship, the letter cancelling. There's no talk of all these things, Lordship.
Let us see. Cancellation.
Cancellation letter was on 21/8/2018. That's page 88.
88.
Page 88.
Yes.
We have received your letter number dated 21/12/2018, and further the order of
Policy guidelines.
Yes, hence we have to closely examine the case with the policy guidelines on selection of distributorship. We have found that as per the policy, the cancellation of LOI is justified and accordance with law.
Yes.
LOI is issued to you dated this is liable to be cancelled as per the policy. We have failed to arrange suitable plot of land within the period of 2 months from the date of issuance of the letter, that is within 13/3/2007.
So you were supposed to arrange the land within 2 months.
Within 2 months.
Okay, now please read annexure 14, page 80. Is the notice given to you before cancellation?
Our notice was given.
So then
I was given the notice, I replied to the notice.
Yes.
I am arranging. So on.
I am arranging, but
Yes.
that by that time, that period of 2 months
Had
it passed long back, expired long back.
Lordship, I-
So how long can we stress the things?
No, Lordship, but my point is that
Yes.
they did not cancel. Had they cancelled immediately after giving me notice after 2 months, matter would have been.
They simply gave you a leeway for the period over and above what was initially indicated.
Yeah, they gave me
That
a
doesn't mean that you get a right to just continue to linger the process on.
Lordship 11/8/17, I was issued the show cause notice.
Yes.
And 4/9/17, I give an application saying that I have arranged an alternative plot of land. I have to inform them. Within 2 months, I've informed
Within 2 months of the first letter,
of the show cause notice.
the arrangement had to be made within 2 months of the first letter.
Correct, Lordship. But then they did not act on that. On 12/1/2018,
That would
I
not,
informed
that
that I
would
have
not
already
give you
got
any
the-
right to get the proceedings drawn out any further, madam.
But my LOI was still subsisting. It had not been cancelled. Had it been cancelled, the matter would have been different. They had
The
rightly
period
cancelled.
of 2 months was never extended by them. Even implied extension, we can't presume. These are matters of contractual.
No, contract has
affairs.
not been entered into as yet, Lordship. I was
So
just
then,
given a
then,
LOI.
it is exclusively within the domain of the corporation that if you don't satisfy the guidelines, you can't be granted the LOI.
But
Very
my point is that before they issued the cancellation order, I had already had the plot of land. I had invested the money.
You were required to provide the plot in
Right.
2 months.
Right.
Very well.
I
Anything
was-
else to say?
I was required to provide which I could not provide, but by their own action, they have in fact extended the LOI. Otherwise, they would have cancelled it, Lordship, from 13/1/17. They would
Very
have
well.
cancelled in 17 itself.
All right.
They would have
Okay,
cancelled
ma'am.
it. That they did not do. They allowed me after I got my plot of land.
Very well.
They issue, and then they do not give me a hearing also. At least give me a hearing.
Okay.
Because the first letter was struck down by this honorable court. They did
Okay.
not challenge that.
Very
Then all I'm asking for is a hearing. And that as per the policy, they can further extend the time. It's not that they're
Okay.
bound.
Very
The
well.
policy permits. I'll just take your lordship to that policy.
Yes, please.
Yeah, leader. I can move it. Sanction to court judgment. No policy for no marker.
Which clause of the policy you are referring to?
I'll just. Lordship, clause 18, clause 18.2, extension of LOI.
Before that, come to clause 7, page 93.
17, Lordship.
93, the paging which is marked on this document you have given to us. Clause 7. Nine point 1.7.
Yes.
So there is no question of any extension in view of these guidelines. Should own as on the last date for submission of the application. Now, please point out that this location can be changed subsequently from the guidelines.
should own on the last date of
Should own.
as specified in the advertisement, a plot of land measuring this. Already this. The part, Lordship here definitely it says should own, but because I think I belong to the OBC category and the women category, that was overlooked. I think so. Otherwise, as
Where is your lease deed? Can you point it out?
lease deed with the owner?
With the subsequent plot which you procured.
This is 8/1/2023. Huh? It's page 76, Doctor. It starts from page 74.
Yes.
Six.
What is the duration of the lease?
25 years.
Where does this reach, the 25 years?
Source 2, Lordship. The lease is commenced
25 years, right? Okay, very well. So this again, if you read clause 8, own means.
Right, Lordship.
Yes.
Right, Lordship.
Clause 8, reference 7 and 8 above.
Yes.
Own means, please read that.
Own means having ownership title or the property or registered long lease minimum of 10 years in the name of the applicant, member of his family unit as defined in the multiple dealers distribution normally of
Norm of eligibility criteria.
eligibility criteria.
As on the last date for submission of the application as is specified in the advertisement or corrigendum, if any. So assuming that the time which they gave you subsequently for procuring the plot on lease was a corrigendum. Even in that 2 months period was prescribed.
Right.
That 2 months period runs out, there is no further permissibility or no further tolerance in the guidelines. Give you any further time.
If Lordship looks at the extension clause.
Yes.
Extension clause, which is at page 18.2.
18.2.
Clause 18.2.
Yes.
In Lordship, field officer should maintain a constant follow-up with the selected, that's their Lordship. Now I look for further extension. Lordship, in case where the distributor select has made sufficient progress, but due to certain genuine difficulties, has not been in a position for him to fulfill the condition laid down in the LOI within 4 months. In such cases, the area territorial regional manager can give initially extension of 2 months. For further extension, area territory regional office should send the proposal for taking approval in the head of the head of state regional zonal office for extending the validity of the time limit of the LOI.
Yes.
A head of state regional zonal office may extend the time limit as deemed fit. So there is no curb on the time limit.
That is all right, but it has to be within a reasonable time. Ultimately, non-establishment of the LPG godown is causing difficulty to the consumers.
Right.
So keeping the things hanging for years together simply because the applicant is not able to arrange for the plot is not at all a good practice, we would say.
But Lordship, till now, no LOI has been issued, no fresh LOI.
Because of these proceedings, that is the reason.
There's no stay order.
Very well.
There's no stay order. And the fact is that I have obtained a plot of land. Now, if I can progress, things would be much faster than issuing.
Well, their plot of land as per them is beyond 15 kilometers. So now there is no question of
At least if they give me a hearing, I may be able to convince them.
hearing is not permissible. Read the clause. It's only a show cause notice which is required to be given. Read the last clause 18.3.
Yes.
Whether hearing is required.
Based on the reply, that this, to put a note with, for withdrawal, with permission. It doesn't talk of hearing.
So it doesn't talk of hearing.
Doesn't talk. It doesn't talk.
There's no question.
But my
The
only.
guidelines do not talk of, the notice has been given, your reply has been sought. Ultimately, it is the satisfaction.
But the point is, they did not even go by the High Court order to give a detailed hearing. They give the same thing they quoted all over again.
Very well.
There was no
Yes,
consideration.
please.
My lord, may I point out another thing, my lord?
Yes.
The order which has been challenged in the present litigation in which the appeal has been filed, that has already been set aside by the honorable single judge in the earlier proceeding.
Which order?
My lord, the order challenged is dated, my lord.
Order which has been challenged in the appeal.
No, my lord. 5/3/2018 is the order by which the LOA was cancelled.
Cancelled.
That was challenged in the earlier writ petition.
And that was
this
set aside.
honorable court was set aside.
Then after we pass the fresh order.
Fresh
Where is that order?
That is not under challenge.
Where is the order? Can we have a look at it?
That order is at page 88.
88.
My- No.
21/8/2018.
Yes.
Let us see the pleadings of the writ petition.
Your lordship will see the prayers in the at page.
Just.
Page 49, my lord, prayer 1. Certiorari right should not be issued, setting aside and quashing the impugned cancellation letter dated number such and such dated 5/3/2018. B also, your lordship will find the same order has been challenged. And this is advertised on 2013, my lord, we're in 2023. And there was a stay of the during the proceeding.
That is a fundamental flaw, madam.
Yeah,
The
that's
order
what I
was
fi-
not even challenged.
That's what I find. I only asked for stay of this, not give effect to 21/8/2018.
Thank you. Dismissed.
Factor number 8.
Yes. Yes.
My lord, we assailed before the learned single judge the demand of additional performance security. And that was apparently rejected by the learned single judge. Now, my lord, learned single judge has also taken a view that that particular clause 26.3 we have not challenged. My lord, there is no question of challenging because we are trying to draw support from that clause only, my lord. Now, if your lordship would kindly come to my lord, page number 67, my lord.
67.
Little bit of facts, my lord.
Yes.
Page 67.
This conditions of contract.
My lord, yes, this is what was challenged, my lord. My lord, we are not saying that, my lord, this condition is bad, etc. We say, my lord, this could not have been imposed because central government who is funding the projects, my lord, they have said such conditions are not required. That is our case. Please see, my lord, works with quoted cost less than estimated cost by more than 10% up to 15%, 100% of the cost difference between the estimated cost less by 10%. So this is how different slabs were made, my lord. Then my lord will kindly come to page 69, my lord.
Yes.
This is the standard bidding document which is prescribed by Government of India, where, my lord, this clause is not there. What your lordship has seen in page 67 is something which has been superimposed by the state. Page 69 is the model standard bidding document prescribed by the central government where there is no prescription. Now, my lord will kindly come to page number 70. because we quoted less than, my lord, 28, about 28% less than the estimated cost. Therefore, my lord, we sought permission from the chief engineer to justify our rate. That is how, my lord, we filed this application at page 70.
Yes.
Please come to my lord, serial 6.
Yes.
It is also pertinent to mention that we are seeking permission for submission of rational justification from your end. So, my lord, at page 71, I was permitted.
Yes.
Therefore, as per clause 26 of instruction to bidder, you are requested to submit justification along with rate analysis for major items. Then, my lord, at page 72, we gave a detailed justification. Page 72.
Yes.
I will lordship to kindly come to page number 73, my lord. After that column,
73.
yes, my lord. 1, 2, 3, 4, 5. Considering the scope of the work provided in RFP, bidding document, a detailed analysis of subhead 7, 8, 9, 12, and 13 of the component has been made, and percentage of the work involved in subhead workable rate based on the market study have been assessed. While analyzing the quoted price, overhead expenses and profit have been considered at 8% and 3% of the quoted amount. The machinery and equipments are all possessed by the owner, that will be deployed at the reasonable cost. That means the contractor himself owns. The rate quoted by us is exclusive of GST. Good quality construction materials are lying under my custody, which will be proposed to be consumed in the work at an affordable price. In the light of the above facts, the quoted amount of 80 so-and-so lakhs is justified amount by which the work shall be executed. So this is, my lord, this was my proposal. My lord, they did nothing, my lord. All of a sudden, at next page, my lord, the demand was raised. This is the order by which LOA was issued, whereby, my lord, I was asked to, deposit the, my lord, performance security. First subpara, you are there hereby requested to furnish performance guarantee for an amount of rupees 25 lakhs, an additional performance security of 3 crores 78 lakhs, so for quoting 27.86% below the estimated construction cost as per ITP number so-and-so. My lord, this is what we challenge before the learned single judge. My lord, when we filed the writ petition, my lord, we based on page 76 OM issued by the government of India.
Okay.
Page 76. This is the OM issued by the government, my lord. Serial number 4. In view of above, it is reiterated that no provision should be kept in the bid document regarding additional security deposit, bank guarantee in case of abnormally low bids. So this was the prescription by the central government. Whenever there are compelling circumstances to ask for additional security deposit, bank guarantee in case of abnormally low bids, the same should be taken only with the approval of the next higher authority to the authority competent to finalize the particular tender or the secretary ministry of the department, whichever is lower. Then, my lord, at page 78, my lord, this circular was addressed to all the state governments.
But whether this was a part of the bid document or
Yes.
the
No, my
tender,
lord, issue
tender.
is not that. Now, what happened, my lord?
Yes.
When we filed the writ petition, we projected our case that you can't even demand additional performance.
The question which we are posing is
Yes, my lord.
whether in the NIT,
Yes.
there was a condition that the additional bid security would be permissible.
Yes, it is there.
So it is there. You
No,
did
but-
not challenge it.
but no,
You
my-
participated in the proceedings with open eyes.
No, my lord, what I'm saying is, my lord, when we filed the writ petition, we
Yes.
projected our case on the basis that the state of Assam is not competent to even, ask for.
So you could have
additional
challenged the
performance
NIT even
guarantee.
if you could have challenged the NIT before participating, saying that the terms are too onerous.
No,
They
my lord.
can't impose
No.
these terms.
Yes, lordship, in a sense, lordship is correct. But, my lord, as now things transpire, it is
Yes.
entirely different tangent. That's why I'm on, my lord. Now, my lord, this was circulated to the government. Now they filed an affidavit, my lord.
Okay.
In the affidavit, my lord, they're relying on page 100 circular, my lord.
Affidavit in opposition.
Yes. First, my lord, will kindly come to page 96.
Yes.
They say that when the November of 2020 circular, which we are relying, that is no longer holding the field. Now, this is the circular which are holding.
Page number?
Now, page number 96, my lord.
Yes.
I am directed to refer to this ministry's letter dated 28th of December, which I read, forwarding here with instructions dated 12th of November 2020, issued by the Department of Expenditure on the issue of additional performance security in case of abnormally low bids. Subsequent to the above tender, this ministry had issued a fresh guideline. Later, sorry, my lord. This subsequent to the above later, ministry had issued a fresh guideline via ministry's letter dated 13th of May 21 on the issue of capping of bids. In this letter, attention of the state duties were drawn towards para 26.3 of the standard bidding document, which deals with abnormally low bid. Now, my lord, the page 100 is that.
Read para two also, which says that the states or UT may deal with the cases of abnormally low bids in accordance with the provisions of so and so of the standard bidding document. Yes.
Now, my case is it has not been done. That is evident from their own stand, my lord. Now, page 101 is 26.3. Page 101.
26.3.
It starts at, my lord, page 100, that's 13,521. The 26.3 is at page 101 towards the bottom.
Yes.
If the bid of the successful bidder is seriously unbalanced in relation to engineer's estimate of the cost of work to be performed under the contract, the employer may require the bidder to produce detailed price analysis for any or all items of bill of quantities to demonstrate internal inconsistency of those prices. After evaluation of the price analysis, employer may require that the amount of performance security set forth in clause 30 of the IT be increased at the expense of the successful bidder to the level sufficient to protect the employer against the financial loss in the event of default of successful bidder under the contract. The amount increased performance security shall be decided at the sole discretion of the employer, which shall be final and binding and conclusive. Now, my simple case is, my lord, when I came before the honorable court, I was of the view that I am not even required to pay. They said, no, you are required to pay as per this. Now, where have you done, my lord? Page 71, 72, 73. I applied for, my lord, detailed price analysis. They permitted. Now, let them show from the record that before issuing the letter of acceptance, my lord, my price was analyzed and verified. If they have done, I am out of the ring. If they have not done, my lord, matter will go back. That is my only case. Now, my lord, kindly see page 72, my lord, eventually when they gave us, returned the file to us, sorry, gave the, at page 71, my lord, I was permitted to furnish. Then at page 72, I furnished the detailed analysis. Now, whether they have acted on the analysis as is contemplated in 26.3. On the contrary, learned single judge says, my lord, that we have not challenged 26.3. Where is the question of challenging? We are drawing support from that. If the record reveals that person to my 71, while before issuing page 72 letter, that my detailed price analysis was done because they have not indicated in their affidavit. Their specific stand was taken.
Considered or this analysis was done.
That's the only point, my lord.
Okay.
I am assailing the decision-making process.
Let us see the affidavit, please. Where is the ground specifically?
Yes.
In your writ petition?
Yes, my
Let
lord.
us see the affidavit in a position.
Page 224, my lord.
Your ground?
Yes. Reply in the reply affidavit.
No, where is your specific ground?
Yes.
Regarding non-compliance of 26.3.
Yes, my lord, 226.
226.
Yes, because, my lord, in writ petition, this was not the projection. In reply affidavit, we have brought out the point. Page para 6. Page 226.
Affidavit in position in the appeal.
In the, yes, my lord. In the writ petition.
Okay.
In our affidavit in reply, my lord, rejoin that. That with regard to the statement made in paragraph 6 and 7 of the affidavit in opposition, the petitioner begs to state that in para 26.3 of the letter dated 13/5/21 issued by the Government of India, Ministry of Rural Development, provides that after evaluation of price analysis, the employer may require that the amount of performance security set forth in clause 30 of the IPV increased at the expense of the successful bidder to a level sufficient to protect the employer against the financial loss in the event of default of the successful bidder under the contract. What follows from para 26.3 notice above is that depending upon the facts of each case, performance security be increased at the expense of the successful bidder to protect the interest of the bidder. But by any legal reckoning, no standard has been laid down in the imprint chart to govern different cases. As can be present. The level to which performance security is required to be increased cannot be determined by applying any straitjacket formula. It will depend upon the rate quoted by the bidder. Therefore, imprint conditions as contained in chart is inconsistent with para 26.3. In any case, price analysis and rational justification has been duly submitted by the petitioner. However, same was not considered by the respondent. The letter of acceptance has not indicated that respondents, after evaluation of price analysis, has fixed the amount of additional performance security. In the humble submission of the petitioner, amount claimed by the respondent as performance guarantee cannot be a static figure, as it will depend upon the facts of this case.
Right.
But this is our case, my. And the
this,
learned single judge, my lord, on the contrary says, we have not challenged this clause. Doesn't it is nothing.
Please read the relevant finding.
One second. It starts at 235, my lord.
So you made out your case in rejoinder affidavit.
Yes, my.
Basically.
Because I have already submitted, my lord, because we proceeded on a different projection. Then only because of the affidavit, my lord, we 247, my lord. Para 16.
As a matter of fact, I am getting a little confused because here the terms reply and rejoinder are not being used, which
We
are
say- We say affidavit.
affidavit in opposition. As a matter of fact, this is the rejoinder.
It's a rejoinder.
And if thereafter something else comes up from the other side, it is a sub
Sir
rejoinder.
rejoinder. Para 16, my lord. A careful perusal of the prayer would show there is no challenge to clause 26.3 of the bidding document. And prayer is only to set aside the requirement to pay additional performance security. It is seen that the aforesaid requirement is not only in consonance with the terms of the contract, but is also preceded by condition required for such exercise. It is seen that the rate quoted by the petitioner is abnormally low, and instead of rejecting the bid, the petitioner on the same ground, the work in question is still allotted to the petitioner by requiring deposit of additional performance security. Such requirement, apart from being the policy decision in the opinion of this court, is also synchronized with the interest of the public service. Oh my lord, the learned single judge was of the view that we have not challenged this 26.3.
Whereas you are relying upon this.
Yes. So this
Yes,
is my
Mr.
case, my lord. If the records reveal that my case, that it was done.
They were
it's a
considered.
different matter.
Yes.
And they'll have
Yes,
to produce the record.
Yes.
So initially his case was that he was.
They were not even aware of this subsequent notification,
Yes.
which you brought on record
Yes.
by way of affidavit in opposition. So they built up a case in
They
rejoinder.
built up a case in their reply
Yes,
because originally they said that they do not want to pay the additional performance security.
in accordance with the prevailing guidelines issued by the OM issued by the central government.
And when we say that we have done it as
Yes.
per the norms, then he said that the quantification part.
So now the issue, plain and simple, small argument which has been advanced is, where is the evaluation as per 26.3?
Lordship will kindly come to, you had given a reply to that also, page 107,
107.
107.
Yes, please.
An additional affidavit filed and on behalf of respondent number 5, countering the averments made in the reply.
In reply. Okay.
So here Lordship will kindly come to page 110.
Yes.
May I read paragraph 5? This
Sure,
was
sure.
in reply. With regard to the statements made in paragraph 6 of the affidavit in reply, the deponent begs to submit that petitioner agreed that clause 26.3 of SBD has provisions for additional performance security, which is again quoted in the Ministry of Rural Development's letter dated 13/5/2021. In the above paragraph, it is also stated that the amount of the increased performance security shall be decided at the sole discretion of the employer, which shall be final, binding, and conclusive on the bidder. The employer here is the Chief Engineer, PWD Border Roads, which was mentioned in the appendix to ITB of tender in which the petitioner participated. The deponent further begs to state that the employer has generalized the calculation of additional performance security and pre-informed all bidders by addition of a special condition in the contract in the bid document in which the petitioner has participated. A uniform formula for calculation of additional performance security is applied to avoid ambiguity protect department as well as bidders from any sort of influences favoritism. Further, the deponent begs to state that the price analysis put forwarded by the
Yes.
petitioner was not accepted. So we have applied.
We have applied, yes. All right, Mr. Chaudhary.
My lord, let them produce the records and my lord, no, my lord.
They
it was
have,
not-
they have
never done.
adopted a generalized formula
Huh.
and thereafter they have applied that.
No, my lord. I'm sure, my lord, my
These are-
learned friend has made out a case to rebut my contention, but only thing is, my lord, this at times, my lord, Everman doesn't do. Let them show, let
You could have
record
made
be
a,
produced.
you,
I'll
you
be
could
out.
have, you could have made a request before SB
Huh.
for summoning of the records.
Or he can
I
file
have
an
done, my
RTA
lord.
application
Or
also.
RTA,
Learned single judge, before learned single judge, that prayer was made, my lord. I have shown my appointment, my lord.
RTI.
No, my lord, lords will kindly come to.
You show us the records.
Yes.
There must be.
Which-
some-
yes, which will
Show the
reflect.
record.
Huh.
Lordship.
When?
Next Monday.
All right. Learned Advocate General submits that the price analysis chart submitted by the petitioner was duly considered before the impugned demand of additional performance security was made. The original, and that he shall keep the original record available for the court's perusal on the next date of hearing.
It can be tomorrow also, Lordship.
Not
We
tomorrow.
may have some doubt again that we have
No,
prepared.
no, no,
Tomorrow,
no.
don't worry, don't worry. Tomorrow would be difficult for this court.
Lordship.
Yes. Deeply.
List on Monday.
Highly obliged, Lordship.
8, 9, 10, same, my lord.
8, 9, 10.
7, 8, 9, 10, same, my lord.
Yes.
7, 8, 9,
8, 9, 10, and 11.
11. 11. 8 to 11.
8 to 11.
My lord, deeply.
The others also same order. Common order can be passed.
Item number 12, for orders.
Yes. Affidavit.
Well, I have filed affidavit day before yesterday. It's one number 9, my lord. That is possibly has not come in record, my lord.
Madam, you have got a copy?
Yes, lordship, we received it yesterday.
So what do you want? Should we call the affidavit now and hear the matter?
No, matter may kindly be listed for admission.
Okay. Then counsel, Mr. Chakravarti has submitted that he has filed affidavit on behalf of the respondent number 9. The registry is that tag the same with the file and re-notify the matter for admission after 2 weeks.
On behalf of respondent number 6, 7, and 8.
Marker attendance.
Item numbers 13 and 14.
In this case, although we have filed an application for granting of stay, I am praying that the whole matter may be heard as per convenience of the.
So you don't press the IA?
Because Lordship will have to hear the whole matter.
All right.
It will be
Then Advocate General Saika submits that
There is a contempt
rather
petition
than
also.
pressing the application for stay, it would be better to hear the appeal finally. Accordingly, the interlocutory application number so and so is disposed of as withdrawn. The connected appeal shall be listed for final disposal. These are 13 and 14. These are 2 appeals, Mr. Saikia.
We have filed only one appeal, Lordship.
Oh, so this is the contempt, sorry.
Contempt.
The connected appeal number 295 of 2022. Where's the other side?
That is why they are not present.
You are there?
Yes, sir, my senior is on legs, sir.
Shall be listed for final disposal. When do you want, Mr. Saikia?
If it is convenient before vacation also, I am ready, but subject to Lordship's
Probably
convenience.
it will be difficult for you.
Only thing is
for
that
us.
let it come after vacation, that contempt we should not be held up.
You advise your client not to proceed with the contempt. Can you make that statement?
Not to proceed with the contempt.
Yes.
My lord, that has been.
The contempt is before us only.
Yes, Lord.
So all right, we'll not proceed with it. Don't worry. List the
maybe
writ appeal as well as the
27th of
contempt case for final disposal on maybe 20th April,
Lord.
20th April.
Highly obliged, Lordship.
Item numbers 15 to 19.
May please your lordship. My lord, in item number 15, there is an IA, my lord.
Yes.
IA number 423 of 2023.
Yes, please.
I'd like to, my lord, raise that petition before your lordship.
The first, there's an IA number 3849.
Yes, my lord.
Tell us what is that about?
That is the, my lord, asking for a stay of the, my lord, the impugned orders.
Impugned tender notice.
Yeah, my lord.
Okay. So which file do you want us to take up first?
My lord, this 423, my lord.
423. Yeah, 423 first.
What happened?
That
my
is
lord,
in
this-
WPC 8169.
8169, my lord.
Right.
Yeah, what happened, my lord, in these, all these matters are connected, my lord. Two matters have already been decided by the honorable single judge. And the appeal is filed against that order, my lord. The central issue has been decided, which is common in my case also. I have filed a writ petition. Since, my lord, the central issue has already been decided and before your lordship, my lord, in the division bench. Therefore, the honorable single judge has tagged my writ petition. So the writ petition is before your lordship.
Okay.
Now, what happened, my lord? This is a PP mode settlement of fishery, which I was running for a considerable period of time. Thereafter, my lord, the authorities had cancelled the settlement on the ground that those were issued without any NIT. So on that ground, my lord, it was challenged relying on the earlier decision of the division bench. Now, my lord, what happened in the meantime, my lord, those orders are challenged in the writ petition. In the meantime, they had issued a fresh NIT.
Okay.
For settlement of that, my lord, through public participation process.
Right.
That has been, my lord, interdicted by this honorable court by an order dated
1912-22.
Yes, my lord. 17/1/2023.
17-1.
17/1/2023.
3.
My lord. In fact, this is a perhaps, my lord.
Order
common
passed in which file, sir?
My lord. This must be, my lord, in my IA.
In 423.
Yes, my lord.
At page number?
Page number 21.
Right.
Page number 21, your lordship will find, my lord, the relevant portion of the order at page 24. Heard Mr. So-and-so, so-and-so. Then, my lord, next page, page 25. Accordingly, it is directed that even if the tender has been opened, it would not be acted upon till 25/1/2023.
Okay.
And that was extended subsequently. My prayer before lordship is that, my lord, your lordship will be hearing all the matters together.
Naturally.
And since that NIT has been, my lord, kept under suspension, till that time, my lord, I pray for a direction that the Assam Fishery Development Corporation may allow me to
continue the fishing operations.
My lord. On daily basis.
On the one hand, we are staying the tender which has been finalized, and on the other hand, we say that you be permitted to operate the fishery. That would be totally
my lord,
unacceptable.
that will be in the interest of revenue also, my lord.
No, sir.
And I
The
have made
interest of
due
revenue would be served if we hear and decide the matters finally.
My lord, if your lordship kindly peruses paragraph 7 in my IA, my lord, I have shown how much investment I have made. And the honorable singers, my lord.
You could have participated in the fresh tender process. What prevented you from doing so?
No, that is for my lord, the investment part that has not been, my lord, dealt with by the honorable single judge.
No, question here is, sir, that now after the 2G case, it is settled that all public procurements to be done through open tender process.
Yes.
Your case, admittedly, the process was not adopted. Now the process is adopted. You don't participate and say that let me continue in furtherance of the illegal process which was adopted by your client.
My lord,
simply because you made the investment, whether that can be a ground to deprive other equally qualified persons from staking a claim for the right to earn livelihood.
My lord, that is yet to be settled, my lord.
So, well, you argue the matters finally. We'll not allow you to do that without having participated in the fresh tender.
My lord, another, my lord, submission that I'd like to make, my lord, while the hearing takes place, my lord. Relying on the earlier decision of the division bench, my lord, it has been, the honorable single judge has decided the matter, but the injury that has been caused to the persons who have made the investment, that part has not been, my lord, taken care of.
That we will see when the appeals are being considered. So what, do you want a withdrawal or a dismissal?
Let it remain, my lord.
No, we'll dispose of this.
Then I'll withdraw it.
Then after arguing the matter, addressing the court for some time in this application for IA number so and so, then counsel, Mr. Chaudhary, who is liberty to withdraw the same, hence this IA number so and so is disposed of as withdrawn.
And so far as the writ appeals are concerned, perhaps your lordship may like.
The writ appeals as well as the connected writ appeals as well as the connected writ petitions shall be listed for final disposal in the second week of May.
Lordship, it will be too late, Lordship. Here, Lordship.
Too late, your NIT is stuck. That is why.
Lordship, there is a problem in the last order that their interim was not extended, Lordship. As of now, no interim is there, Lordship. We can go ahead, subject to the outcome.
Go ahead. We are not stopping you from proceeding.
Lordship.
List for final disposal in the second week of May. Yes.
My lord, in item number 18, my lord, there's an application for impleadment, my lord. I have prayed to implead the respondent who has been, the settlement order has been passed.
Pass in favor.
Bill has been
18 में आइए दे दीजिएगा.
IA number 699.
699
of 23, my lord.
Yes, 699 दीजिएगा. Issue notice of the interlocutory application to the respondent sought to be pleaded in the writ appeal. Issue notice to the respondent number 4.
Respondent number 4.
Respondent number 4 in this interlocutory application.
And my lord, in item number 19, it's a separate matter, my lord. It is not tagged with this series, my lord. But in this case, my lord, what has happened? Earlier, when we had filed a writ petition, there were 4 private respondents, my lord. They were the eligible bidders. But out of that, only 1 has been selected. So the remaining are not necessary in this case, my lord. I pray for striking
deletion of name, striking off.
Oh, yes, my lord.
You filed the application for that purpose.
No, I have not filed.
Oral request.
I'll file an application.
No, we'll do it on your oral request. On
item number 19, my lord.
19. That would be the on the oral request of learned counsel. So and so, comma. The names of
respondent number 5 to
respondents numbers
5 to 8, my lord.
5, 6, 7, and 8 are struck off from the array of parties in this appeal. Amended cost title be furnished within 7 days. You file an amended cost title.
Yes, my lord.
List along with the connected writ appeals on 2nd May.
Highly obliged.
May it please your lordship, my lord. Look, this is with regard to, my lord, delay in construction of that highway in Harangajao, Haflong road. On the last occasion, lordship was pleased to direct for personal appearance of the project in charge.
Project director.
Okay. Yes, my lord, project director. That is your lordship's order dated 27 to 2023.
What is happening, Mr. Counsel?
Yes,
Why
my
is the
lord.
delay?
Or this, we have explained in very first day, it was on 15 to 2023, my lord. Order was from this honorable court to file affidavit in regard of completion of this. And accordingly, we have filed an additional affidavit stating reasons. But that last occasion when case was listed before me, then when lordship pleased to call for the concerned project implementation unit director.
Yes.
I said he's present because it's a technical issue. Your lordship main issue was there because here we have already stated in our affidavit the 3 packages. One package number 1 had already been completed. Second part is taken by NSIDCL. They have filed with another package S21, my lord. The issue now regarding 21, according to us, my lord, earlier two contractors as could not be, they could not complete the tasks. We have taken tasks. Then we have already terminated them. Thereafter, now present contractor who we have signed, they have signed on 27 May 2022 agreement. After verifying all this thing, they have started work from 16/1/2023.
What is the duration now given to
Duration
him?
for that was for, as per appraisal committee authority, my lord, that was decided for 3 years. Accordingly, agreement was for 3 years. But lordship's pleasure is to further I may be only due permission only I'm submitting, my lord. This is lordship's this one, whether it can be
Expedited.
can be reduced 3 years, because as I have submitted before your lordship on last occasion, because it is a technical issue. This is concerned, chief lordship is kind enough to call for my project director. He is the project.
All right, let us know from him.
He will
Let us know from
express
him.
this
Yes.
region, Miller, how to expedite.
Please tell
the
us,
case.
what is the reason for the delay? For this 3 years period? What is the stretch of the road?
Space of the road is 49.230 kilometers.
Okay, for that 3 years is required.
Yes, sir, because the project cost is 1,600 crore. And we are giving 1,000 days for construction in 3 years. So on an average, it requires to execute 1.5 crore per day.
Mhm.
The quantum of work is very high, sir. Secondary, so many technical new inputs we are implementing in this project. So that requires sufficient time. Plus, sir,
What is the nature of the terrain?
it is fully hilly, sir.
Hilly. Okay.
And sir, we have very less working season. Working season is, means we are only for dry for 6 months. So sir,
During rains, the work is stuck totally.
not totally, sir, but most of the work is stuck.
Most of the work, because if we go for, because landslide is frequent happening, even auction going on, my lord, and lordship, we do not know when it is fall down. So once I went to Gangtok like situation, I was escaped narrowly. Because well as going, suddenly lands will come. Lordship is aware, my lordship is aware, I think. This Arunachal also same problem, landslide is going on. There is a region, Miller, and appraisal committee has verified all the things.
Okay.
Because now he only on due permission only I'm submitting as a project implementation PD. He has to implement that accordingly, because agreement was for 3
Naturally.
years.
Agreement is for 3 years.
3 years, 1095 days. We are giving in not only 1095 days. It's where days we are given, my lord.
Mr. Das,
Lord,
if the contract period is for 3 years, how can we force them to do it at an earlier date?
That's true. We are in a lesser bargaining option, my lord, at this moment. But fact remains that initial contract was awarded in the year 2006. That is one aspect of the matter.
Right.
Yes.
The contractors, even when
Now-
we were taking up that Dimapur Kohima highway matter through VC, same situation.
Yes, yes.
Contractors go away. What can the NHI do about that? NHI DCL.
Only concern that I am having is that I believe there is no flaw in the DPR. Because why I'm saying so, 3 contractors in the meantime, they have escaped from their work. That if otherwise.
Mr. Das, who wants to leave the work and go away?
That
has got severe civil consequences.
True, true.
Losses suffered.
Terrain is also very difficult.
Terrain is difficult.
That is correct.
So if we try to force their hand to do it earlier, maybe the quality will be compromised.
Quality, there is possibility.
And if the work could not be done from 2006 to 23, to expect or to direct that it should be done within a period of 2 years, then that will be
At
too
least I
harsh.
hope, my lord, during the pendency of this proceeding, this project finishes, my lord. At least that is the best
Yes.
we can expect.
That is
If
we
we,
also
if we,
expect, my
if
lord.
we call for a report of work which has already been completed, the effect of the subsequent weather conditions So probably we'll be back to the square one.
Yes,
Road must be damaged at many places.
many places in the coming monsoon season, my lord, there is possibility.
That's right. So we'll just keep it pending.
Lordship.
Let's see the progress.
Let's see the
Definitely,
progress.
my lord.
What has been done after the fresh contract has been awarded?
Now it is full swing. We can give submit photographs also. Moreover, my lord, these roads, this is as you know, 4 lane. So another 2 lanes when we are working, another 2 lanes are fully motorable, my lord. That
Okay.
is, we are submitting at affidavit. And on affidavit, we are submitting. That's.
You will be
this-
filing the affidavit today?
No, no, today, no. It is already.
You already filed the affidavit.
Filed, that is, we have stated that this road is in motorable condition.
Okay.
Because we are getting only advantage of this when 4 lane, my lord. On a 2 side we are working, another side we can open. That is keeping open, my lord.
All right.
That is, we are on affidavit, we have stated that part.
Lordship can take up the matter after a few months, my lord.
Yes.
No, definitely.
All right.
We want
The-
your lordship's
in the
observation
meantime-
is required.
All right.
In the
The
meantime, they will come up with an.
Project
affidavit
director,
program.
Mr. So-and-so is present in the court
A Lal, Mr. A
In-
Lal.
pursuant of the direction given on 27/2/2003. This court is apprised that the fresh contract for the stretch number 3,
No, 21. It is package, your lordship is.
Package 3.
Package 21,
package 21
my lord. That is.
of the so-and-so road has been signed, and that the duration of the work is 3 years. The project director states that all efforts shall be made in full sincerity to ensure that the road project is completed within the stipulated
My lord.
period.
My lord.
The personal presence of the project director is dispensed with. The latest factual report is submitted for the court's perusal on the next date. Re-notify in the month of August
My lord.
2023.
My lord,
My lord.
deeply obliged.
Obliged.
May it please your lordship.
Yes.
Lordship, this petition is directed against the order of the learned CAT
Yes.
dated 15th June 2016 that your lordship will find at page 9.
Yes.
And the relevant paragraph, lordship, is that paragraph 8, page 12,
HRA.
HRA, lordship. Here,
Yes.
the HRA was denied and the learned CAT said, no, the HRA has to be paid. Now, the only thing that lordship has to see whether under the rules, whether the HRA was
Admissible or not.
was admissible or not. In fact, lordship, a review petition was filed against this order, which was rejected by the learned CAT. CAT says that if you want to go for an appeal, you may, but review is not permissible.
Right. So,
Now, may I take your lordship to page 35 and 36?
right.
The respondent's lordship, respondent had given up the accommodation
On our own.
on her own. Now, as per the rules, lordship, I would take your lordship now to the rules. That is at annexure 4, page 42. And
Just hold on.
lordship,
Whether there was a prayer in the original application for questioning the order dated 1st July. Let us see the pleadings.
lordship,
1st July. Yes. That is precisely what is prayed for.
yes, lordship.
But all right, the CAT says that there is no provision for withholding the
Yes.
HRA.
So
Let us read the rules.
that your lordship will find in the rules, which is annexed as annexure 4
Yes.
at page 42.
Yes.
And if your lordship will take up the letter dated 1st July 2011. That was at page 35, which your lordship has just seen. At the first paragraph,
Just hold on.
page 35, lordship.
Yes.
The first paragraph, the applicant was aggrieved by this portion. The request submitted by Mrs. So-and-so to vacate the quarter has been accepted with effect from 31/7/2011, but she will not be entitled to draw HRA.
That is at page 36.
Uh,
1st July 2011. You are reading that only.
I am reading, there are two documents of 1st July, lordship.
Yes.
One is at 35, one is at 36.
36.
I'm reading the 35.
35.
35.
Right.
The first paragraph, lordship, the last sentence of the first paragraph.
She will not be entitled to draw HRA.
She is aggrieved by this.
Yes.
Now, lordship, if we see rule 4A,
Page number.
relevant page will be lordship page 44.
Right. 4A.
May I read out lordship A1, A2, and I'll just make a reference to the next page also. The grant of house rent allowance shall be subject to the following conditions. To those government servants who are eligible for government accommodation, the allowances will be admissible only if they have applied for such accommodation in accordance with the prescribed procedure, if any. But
So there has to be a no accommodation certificate. If the accommodation is available and the government servant does not apply or does not accept the accommodation, then no HRA is admissible.
Here is a case where she had availed.
Vacated and then vacated on her own.
Whereas it was available. So lordship, that is the precise case, lordship.
Yes.
Here again, I would take the lordship to the next page.
Sure. Carry on.
Page 45, the last paragraph, it starts with reference.
Yes.
The reference is invited to the policy decision contained in the Directorate of Estates memorandum number so-and-so, which was circulated to all the ministries, departments of the government of India, and which it was decided by the government decided by the government that the government servants eligible for general pooling accommodation do not submit applications for such accommodation, or those who after submitting such application refuse to accept the accommodation offered, allotted, or those who have after accepting such accommodation surrender it, may not be paid house rent allowance without obtaining no accommodation certificate in respect of all types of accommodation. So lordship, basically there was accommodation which she had availed.
And then she vacated.
That is. Therefore, lordship, under the rules, I would submit.
HRA was not admissible.
It was not admissible.
Right.
Perhaps, lordship, very well, I can understand that there was no pleading to that effect before the tribunal, but the order has to be correct.
Yes.
My lord, Government of India, Ministry of Finance, as well as Ministry of Urban Development, my lord, Housing and Urban issued office memorandum from time to time. If lordship may kindly come to my affidavit in opposition.
Yes,
my lord.
please.
First of all, my lord, page 12, if lordship may can.
12.
Lordship,
Okay.
I am reading, my lord. Subject, dispensation of conditions of applying for government accommodation and furnishing of no accommodation certificate for admissibility of house rent allowance. In pursuance of the Ministry of Finance, Department of Expenditure, OM number such and such dated 5/3/2019, and in supersession of these directors, OM number such and such dated 14/11/2007.
Just hold on, sir. Hold on. Your affidavit in opposition is not available.
Which page?
Page
12, my lord. Affidavit in opposition filed on 29/4/2022, lord.
It's not available.
Page 12 is order.
Part of the OA. Yes.
No, not part of it is affidavit in opposition, lord.
In fact, I have received it on 6/8/22.
There is an index. It's not there. Get that affidavit. Yes. So there might be some defect pointed out by the office.
Lordship will take it up in the next week. Lordship.
Yes,
Maybe
definitely.
Thursday or Friday.
Yes, next. When counsel for the respondent submits that affidavit in opposition was filed on
My lord,
Lordship, I received a copy on 6/8/22.
in the month of August 2022. The rest is that to check and tag the affidavit with the record and re-notify the appeal for hearing, our writ petition for hearing after 2 weeks.
you please.
Yeah, I deserve a fine.
May it pleases your lordship, we need further 1 week time to obtain instruction, your lordship.
You are applying for the Union of India
Yes, your lordship, for appellant, your lordship.
and counsel MS so and so appearing for the appellant
Central
Union of
Excise.
India, Central Excise Department, raise for and is granted 2 weeks time to complete our instructions.
Deeply
Start
authorized.
2 weeks. This was part of yesterday. Equivalence,
May it please your lordship.
yes.
Yes, day before yesterday, lordship was pleased to ask me whether that was gazetted or not, that equivalence notification.
Yes, yes.
And before going further, I have to submit before this honorable court that I am not getting proper support from my officers because there is a direct conflict of interest. They were hiding some files yesterday and finally we have to influence all other things to find out those tracks.
You need more time?
And I do not need time, Lord. I'll not seek any further time.
Okay.
So we traced out without their assistance,
Okay.
one file, how this was moved.
But tell
Then
me,
finally they
tell
said
me,
that-
Mr. Saikia,
Lordship,
are the gazette notifications not uploaded on the website?
it was not uploaded, Lordship. I'll just come to this. If Lordship is pleased to come to that notification.
Just page number?
It is page 110, 11. Good notification continuation.
111.
111.
Yes.
Writ appeal 167, 111. Here, copy, what the other side has annexed is copy marked to only one person. But I have the copy which was marked to about. The actual notification, Lordship, I'll place that notification. Where one copy was marked to the director of press from where the notification is to be gazetted.
So
Till
come
now, we did
straight,
not enter into the merit and.
come straight to the point. Where's the notification?
Yes, Lordship, I'll come to that. That notification, in fact, is not material at all. I'll
So
come to that.
we
I'll come to
can,
that.
we can presume that it was not gazetted.
This is just now I have got this. That will have no bearing in the present case, Lordship. Whether
That's a
it was-
different thing. Could not be traced out.
Could not be traced out just now because they said it was not, they did not give me a concrete reply. Till now, they are keeping me
In dark.
in dark. And Lordship is pleased to look at the actual notification. It was marked to the Accountant General Assam, Chairman, Assam
Saikia,
Administrative
if there
Tribunal.
is no publication, it is no notification in
No,
the eyes of
it is a notification because we have to go by the General Clauses Act. I'll place that also.
Okay.
But otherwise also, I'll come.
Ignoring the notification.
Ignoring the notification also.
Okay.
Then Chairman Electricity Board, Assam Board of Revenue, Principal Secretaries, various things. Then about 30, it was issued to about 30 persons,
Right.
including the yes, 23, Deputy Director, Assam Government Press for publication.
Assuming, what happened thereafter? It was marked, but then it never,
What happened thereafter is
never
this.
saw the light of the
No,
day.
I'll go to that. I have a complete different sets of argument today.
Okay.
Then today, this is the result. From last evening, this is the exercise we have done because what
So
they have enacted.
you mean to say that the IAS lobby has prevailed?
No IAS lobby, ACS lobby.
ACS lobby.
ACS lobby. And the persons who were briefing me are all ACS lobby. And I will place one judgment where my Lord Justice Ete was also arguing in Arunachal. I will place that judgment also now. So what they have done, Lordship,
Yes.
the other day, Lordship was came up very heavily on one set of advocates because they suppressed the material facts. Here they typed this copy without mentioning all the persons to whom it was circulated. This is the actual copy.
They must have placed the photocopy also on
No, no,
record.
they have annexer F, only one, SO to the Chief Secretary.
Okay.
See their conduct.
But then this again, Mr. Saikia, this is again a typed copy.
No, this is not the type.
This is a typed copy, SD.
Next page, Lordship, can you see?
Can we have a look at the original order?
Original also.
Order bearing the
Original also
signatures,
I am placing.
signature of Mr. Tapan Chand Sharma.
They suppressed one whole file from me yesterday. I'm going to place a very serious complaint against all these officials. And I requested them to see the live proceedings also. They cannot play with the honorable court.
Naturally.
All the facts should be placed. We have nothing to do whether we win the case or lose the case.
No, that's a different thing.
That is
But
a different.
can we have this document?
Yes.
Which bears the signatures of Mr.
Yes,
Tapan Chand
I'll
Sharma?
try to find out, Lordship. Just 1 second, Lordship.
Have a look at it because they're very surprisingly, here it is SD and here it is signed by order.
That when it is a copy, Lordship,
Yes.
always at the below, it is
Right,
signature.
right.
The
Okay.
first copy bears the signature at the top.
So,
In the file, this is the copy, but here it is also a photocopy. And when they said that it was not notified, I wanted them, give me a copy today, that it is not notified. Then they gave me this. They could not trace out. That is a new idea they have floated. That means they might have published it, but they are hiding.
Hiding it.
I think we have to file it from our side, from my office, an FIR to look into this whole affair. We cannot leave this kind of things happening
Definitely.
to the
Probably
Advocate General's office
they
or
might
to the
be,
honorable court.
they might be connected through the YouTube. Maybe they might realize the folly of their actions and come out with the document. It's quite possible.
Quite possible, Lordship. That is why this is a side thing, Lordship. Now let us see what they have challenged. On merit also, I am entering little bit. But before that, I will also place how it is not maintainable. I will come to that argument also.
Okay.
What they have challenged, and in fact, they have seen the trailer of the movie. The main movie was subsequently held in December. When it is the committee is the central government's committee. The meeting of the UPSCs, not the meeting which was held here as a part of the screening committee's level selection.
Okay.
What they have challenged the this 18th October's meeting held in Guwahati. They have challenged that. Where it was a process of screening, what they have challenged, Lordship, will kindly come to page 106.
18th October.
18th October. 18th September, sorry.
18th September.
18th
It's
September.
at page number 47. 106.
It's an appeal of the state, Lordship.
Yes.
Minutes of the meeting of the selection committee for preparation of list of non-SCS officers to be recommended for nomination to IAS for select list 2016 held on 18/9/2017 at 12 noon in the office chamber of the Chief Secretary. So the members present was the Chief Secretary, Alok Kumar, and the additional Chief Secretary, Ravi Kota, etc.
Yes.
What they have, I have gone through the file. They have requested all the departments to nominate their persons. And this committee, the committee was informed that the DOPT government of India had determined 2 vacancies under Regulation 3 of the IAS, appointment of selection regulations 1997 for the select list of 2016. Accordingly, all the departments of the state governments were requested to submit their recommendation in respect of non-SCS officers who fulfill all the criteria as laid down in the regulation 4 of the IS nomination by selection regulations 1997. 15 non-SCS officers were recommended for consideration for nomination to IS by various departments as follows. 15 members were given. As per regulation 4 of the IS appointment by selection regulations 1997, the state government can propose 5 names, the number of vacancies for consideration for nomination appointment to IAS. Accordingly, the committee examined the service statements, ACR statements, integrity certificate, achievement, appreciation letters, etc., and recommended the names of the following 10 officers on the basis of outstanding merit and ability for further submitting to selection committee of UPSC for consideration. So out of 15, 10 names were recommended by them. The meeting ended with a vote of thanks from the chair. This was put to challenge in the writ proceedings.
Yes.
And the next is, Lordship, they have challenged this notification of 27th October at page 110, where they have not copy marked to only one person. They have indicated they have suppressed everything, just to make out a case that it was not gazetted or not notified. And the learned
It's like
single judge also said,
irrespective of what type copy they have presented, you had the opportunity.
no, we did not
Before the-
avail that opportunity because we argued only on the point of maintainability on merit, not a
So
affidavit.
even-
was filed, not a
even in this
single word
court,
was uttered.
Before you argue on the aspect that the copy might not be the accurate reproduction of the original, but you still have the opportunity of producing the original gazette notice.
It was not required because
That's a different thing.
Our limited point was, Lordship,
Yes.
by taking the 2015 judgment of the learned single judge in Arunachal Pradesh bench.
Yes.
Identical issues, Lordship, we argued that only on the point of maintainability.
Maintainability.
And the learned single judge also finally said that you file an affidavit.
To what effect?
To file an affidavit after saying that, passing the whole opinion about the merit of the case as well as holding the-
This is an interim order you are coming against. Right?
Exactly, Lordship.
Yes.
So this is now, instead there are 30 persons whom it was circulated. The learned single judge held that there is notification of 27th October was never circulated nor gazetted, but it was circulated. It was circulated to 30 persons. And
Right.
the learned single judge came to that view only because copy marked to SO to the chief secretary.
Read that finding, please.
In the judgment, Lordship.
Yes.
Yes. Para 14, Lordship, I have marked it.
1-4. Never circulated nor
Yes.
gazetted.
Para 14.
Yes, yes.
Interested, this equivalence declaration notification was never circulated nor gazetted, but was simply marked to the chief secretary of Assam. So the honorable single judge was misled by the wrong factual submission of the petitioner
Then
side.
the circulated copy has to be brought on record if you want us to record any finding on that.
I have the whole record before this honorable. We'll file an affidavit to that effect.
You have to place it on record, provide the copy to Mr. Chaudhary.
Yes, Lordship. We'll file it. Let us file an affidavit to that effect. I do not
That
trust
will be-
any of my officers who are
Yes.
briefing me now.
You have to be careful, more careful. You're
Exactly,
treading
Lordship.
on.
That is how luckily I said that I have to take instruction the day before yesterday.
Yes, yes.
And this morning I said, give me on writing that it is not circulated or nor it was notified. Then this is the response I have got on record. They themselves are not sure or they know it and they are deliberately.
Obviously, they know about everything. Would not be traced at the Assam government press. A government document, a communication.
When I said, give me on writing straight away that it is not circulated or not notified, then this is the response. Now, this is a very serious thing because
This is
what I am
no doubt.
submitting before this honorable court,
Yes.
it is their submission before this honorable court. They are not obliging me.
Naturally, because this is a case wherein the association is comprised of those very officers
Same officer.
who are
conflict.
briefing you. And if they are concealing the
And
documents,
Lordship, I spent 2.5 hours yesterday with them. They did not show me that file. After that, I requested my friend to further look into it. Then that file came up where all the processings regarding this
circulation is there.
was there.
Why can't we have the original file with us?
Yes, Lordship, we have procured everything.
So can we see the original notification, please?
Original-
That is not traceable.
Lordship will kindly give me, because I have to go all through before placing it properly.
Very well, you have a look at the
Yes.
the files completely.
Yes.
Study it and come back.
Yes, on Monday, Lordship.
We'll have to constitute a special bench. Yes.
And I will argue on merit also. I am prepared
Yes.
today also for arguing.
Saika submits that.
My lord, next week I have some difficulty, my lord. My lord, if tomorrow, today the Maharashtra matter ends, then our matter will come up on Tuesday. So can you also keep it on the following Monday or Tuesday, my lord? Only.
27th, I have some difficulty.
lord,
28th, I am
My
available.
lord, my learned friend has said that he will file FIR. There are so many other cases where FIR is required to be filed.
Now
I
he is
give a
trying
list
to
to my lord.
divert
I
the
give a
case.
list of the cases
Divert the case now.
when FIR is supposed to be filed.
Now here there is a
And my
clear
lord,
case
here
of
is the case.
suppression of facts.
My lord, he's coming up with big, my lord, slogans. My lord, let's state first clear his own home, my lord. Because of the state government's illegalities, these people are benefited.
Absolutely not, Lordship. They have totally misguided the
As
honorable
if my lord,
single
the
judge.
present government is the
All right.
only government who is following the rule
Now
of law.
all the
Otherwise,
political statements will come up.
Political
All right,
statement.
Mr. AG, Mr. Saika
My lord,
submits that
everybody knows what is going
as
on
per
where.
submits that he has doubts regarding the bona fides of the officers briefing him in this matter, because the requisite information regarding publication, gazetting of the notification dated October 27, 2017 has not been provided to him despite repeated instructions. He needs more time to study the original record and file an affidavit in this regard. Probably these observations might galvanize the action.
My lord,
Yes.
I have a small submission. my lord.
Yes.
Lordship, I keep the matter on Tuesday next. In case, my lord, I am not there, Lordship will kindly accommodate. Lordship can keep it on Tuesday. If it is not listed, then I'll not.
List on for further hearing before this bench on 21st March at 2 p.m.
Deeply
Yes.
obliged, Lordship.
In case, my lord, I am not there, then my lord, my junior will make a prayer.
You have to inform a day in advance,
Yes,
because then
on
we'll
Monday
have to
itself, on Monday
reconstitute the bench accordingly.
Monday itself it will be done.
Highly obliged, Lordship.
My lord, one more thing, my lord, this submission which my learned friend has made, it will have a bearing on the, my lord, the merits of the case. And therefore, my learned friend will have to stand by it, my lord.
Of course, of
Of
course.
course,
Because we
Lordship,
will
goes without saying.
pursue this.
This is all
We will
recorded.
also pursue this.
Goes without saying,
Yes.
goes without
He
saying.
must stand by it.
Yes. But
We know
definitely,
what we
Mr.
speak
Chaudhary,
And we take care of every word we speak before this honorable.
definitely, the information is being withheld.
Yes, my lord.
That
he
is
will
for
have a
sure.
bearing. Therefore, my learned friend will have to stand by it.
Yes, yes.
Tomorrow he cannot.
On
say,
writing,
Now
I
it
have
is recorded. Now it
Yes,
is
yes.
recorded in the court's proceedings.
Highly obliged, Lordship.
Statement made by Learned Advocate General.
All the Holy Council now come to the court. Deeply obliged, my lord.
Okay.
Whom to assign for?
Yes.
I will want to.
Yes.
Doesn't it? It would go in the.
Lawyer has to have that.
No,
Being able to pursue. It's aggressive, but not offensive. So that's fine. Yes,
It took out of this as a devices of control. Made prisoners.
there are few writ appeals, there are few writ petitions.
Yes.
The writ petitions are single bench writ petitions.
Single bench, my lord, because my learned friend made a mention.
the constitutional validity.
Anyway, my lord, in any case, it will be tested in division bench, therefore why not in the first? go it is decided.
One chance of appeal is being given up. Okay,
Yes, yes.
yes.
Anyway, my lord, we are prepared for that. In any case. it would have-
Reservation in promotion,
Yes. My lord, what had happened?
will we be able to complete it by one? Because
Certainly
at
not.
2, the bench would be of,
Certainly not, my lord.
so then
It will take some time, my lord.
Then, Lordship, since we are prepared,
Lordship will fix it on Tuesday because the matter relates to the entire scope of public employment. 60 departments.
Tuesday, we have placed one matter at 2.
Yes, my lord, the urgency.
Thursday, we can have it.
Because of the OM, we were brought down and there is a series of cases. So the all the
understand.
officers
We
are stuck
understand.
up at different levels. He'll agree to
I
it.
think my learned friend will bear with us for a day or two. Nothing is going to
Yeah,
happen,
yes.
my lord.
So let it, can it be on Thursday?
Lordship will have it in the following week, my lord.
Yes,
That will be better.
following week.
Yes. On Tuesday, my
Can
lord.
it be on
have it
Thursday?
on
Can I
28th.
make a prayer on Thursday?
28th, come on,
yes.
28th.
Yes.
28th, I have some problem.
Okay.
And then it goes beyond 14th April.
No, Malad, can it be on Thursday? Can I make a prayer? Because, Malad, since the entire constitutionality is
30th,
challenged.
we'll have it on 30th if it's okay.
20,
30 is okay.
30.
Malad, 23rd will be.
23rd will be difficult, sir. We already posted many
Then
matters.
I have already agree with the lordship. Let it be on 28th.
28th, okay.
Oblige.
My lord, in this series, I have got an item, my lord, item 46. I have to make a little submission, my lord, on service. What happened,
On
my-
service,
Yes.
okay. Let's see.
What happened, my lord? The office note says the respondents number 7 to 9 and 11 to 13 are not served. On the last occasion, my lord, I had requested some time. Your lordship granted time to offering instructions. Now, my lord, 2 of the notices have come back because of wrong address, insufficient address. But
You
the
take steps.
question here is, my lord, all these respondents who are not served, they filed the application for implement and that is how they were implemented and we have given this, my lord.
Implement in this very red petition.
In the petition, yes, my lord. And my learned friend appeared for most of them, my lord.
Mr. Council, please check.
We do not know, except 2 persons who have retired, we can strike out their names, but the rest of them.
You are talking of respondents numbers?
We are appearing
6
for
to
the
13.
officer on whose case I won the judgment, Bhagavan Patar, he is there. So the other officers, the respondent 6 was the person who was originally in that.
The red petitioners.
Because the general through equality forum challenged it, that was rejected. So in fact, respondent number 6, I am the who is there. Others
That's
never
okay.
appeared.
But regarding the other respondents, if matter is still stuck up for service, we'll not be able to take it up now. That is the problem.
In fact, 2 judgments.
My learned friend can open instruction.
In fact, this case will be connected with 2 cases where the constitutional validity of the 78 Act is there. That may, we are giving the numbers that may be tagged along with the equality forum. Because there, in fact.
Would that take care of service?
Malad?
The issues regarding service upon respondents. Which of the respondents are to be served?
My lord, 7 to 9 and 11 to 13.
7 to 9.
And 11 to 13.
So 10 is served.
10 I appear.
You
10 is
appear.
served. Then my lord,
6 and 10 I appear.
for respondent.
Malad,
number-
9 has retired, my information.
You are attending for 10?
Yes, yes.
That may be recorded because my lord, this came back with insufficient address.
Yes, Malad, he's back because that officer is in the series. He was brought down. Definitely.
Number 10. So right, mention in this appeal. Mr. So and so puts in appearance on behalf of the respondents numbers 6, 10. 6 and 10.
Yes.
Yes, my lord, if he provides me the address, I can take steps again, my lord, or he can appear because he appeared in the, before the single bench.
Are you having the address of the other respondents, sir?
Malad, the respondents belong to the general of which the equality forum is espousing the cause. It is, I cannot provide information for the.
Steps for
But
effecting
they will be
service
in a better position.
on the other unserved respondents.
For the reserve.
Be taken
To that number detail.
immediately. Thus the service is permitted. List on 28.
My lord, we will not know their address because they implemented and they give their address.
That is your problem, sir.
How can it?
My lord, we'll
be
take
my
steps
problem?
again. No, you appeared for them.
No, I appeared for those person whom I am appearing again.
Okay.
I won the case, so I have to appear.
Okay, you lose the case here anyway.
28.
Obliged.
file affidavit, my lord. We have already sent to the ministry, my lord. Item number 2, my lord. We have already taken the consent of all the
On behalf of Union of India
Union of India.
and Council MS.
A, my lord.
So please for, and is granted 2 weeks time file affidavit on behalf of Union of India.
And can it be taken up after 3rd of April?
Let's start for 4 weeks. Okay.
Must oblige.
Item number 1 of daily list.
May it please, Your Lordship.
Yes.
So this is a PIL basically against the destruction which is taking place in the only Ramsar site in Assam, that is the Deepor Bill. Well, Ramsar Lordship is an international convention which happened in Iran. And this site is important for the simple fact that in 2014, Lordship, I'll just come to the facts. In 2014, one Rohit Chaudhary Rohit Chaudhary, he filed a case in the National Green Tribunal against statutory violations under the wetland rules, the solid waste management rules, and a slew of directions was passed. On April, Lordship will come to the order dated page 208, annexure 6 of my petition. Order dated 28/4/2002.
Yes, please.
My lord, all the departments of the government represented, and the issue was that prior to the Deepol Bill, since 20 years back, it was a dumping site. And Chaudhary brought to the notice of the court, tribunal, that this was against the statutory provision. And it was in such a fragile zone that there are two issues which will come up. One is a railway line which is going through, because this Deepor Bill is a wildlife sanctuary, and near it is two reserve forests, the Garbhanga and the Rani. And elephants do come through corridors, 5 corridors are there for the water part, and they have to cross the rail. And in fact, there were incidents, 10 or 12 elephants have died. Now, the people in the fringe villages, the order which was passed by the tribunal was, the government took a categorical stand that we will shift the dumping site from there, and Your Lordship will come to the affidavits filed by the different departments. First, I'll come to the affidavits. Lordship will come to page 213. This is 10. This is 213, Lordship, if I may read.
GMC. Yes.
The affidavit filed by the GMC mentions status of dumping sites, legacy waste, declaration of ESZ, establishment of decentralized and integrated waste management plan. Relevant extracts from this affidavits are a discontinuation of the dumping site at the Boragaon site. The Guwahati Municipal Corporation has stopped the transfer of solid waste management to the old site at West Boragaon with effect of 28 June 2021. The said site was locked and no any solid waste has since been transferred dumped to this site. The Guwahati municipality starts transferring solid waste to Chandrapur site. Further, at present, the solid is transferred to another called Belortol in West Boragaon of Guwahati with effect from August 2021. So what had happened, this factual part is very important. There was a hue and cry because the Lordship knows environment, people are very aware. These are the 3rd generation rights. Now, when they protested, it was shifted to a place in Chandrapur, and rightly the government was also wanted that issue should be solved because it was of public interest. When it was shifted there, there was another protest out there because no one was allowed.
Across the country.
Yes. Then what happened? This was again shifted to Belortol. The problem is that Belortol is just near the Deepor Bill. Now the dumping goes on, and rivulets from Guwahati in the southern part, they go, the Bahini and the 3 rivers, they go and fall there because that becomes a storm water for the Brahmaputra because it acts as a sponge. Whenever the winter comes in, and it's the rare bird species are found, elephants do come in, and it's basically very rich in the biodiversity. Now, what had happened when this was shifted, the Lordship will find that in the order of the tribunal, the monitoring was being done from 2014 till the date the order was passed on April 28, 2022.
What is the final conclusion?
Yeah, before the final conclusion, Your Lordship, I'd like to read 211, 215 part, this is very important, 11. If I may repeat, while the monitoring was going on, this was the finding of the court. It is seen that solid waste is not being sufficiently managed, nor legacy waste has been remedied.
You are reading at page.
At page 215-11 down.
Yes, okay.
Can I read?
Yes, yes, please.
It is seen that solid waste is not being scientifically managed, nor legacy waste has been remediated. Capacity of proposed integrated waste
Management plan has not been specified.
has not been specified. There is also no water quality monitoring program of the wetland. In spite of monitoring by the tribunal for a long time, no satisfactory progress has been placed in far. In fact, estimated waste generation is said to be 600 TPD. There is thus need to work in a mission mode to remedy the legacy waste, scientifically handle current waste, speedily set up plant of adequate capacity, regular monitoring of the water quality of the wetland, and other measures which is identified. No ongoing project should disregard the environmental safeguards and should proceed further only after addressing the concern set out in various orders of the tribunal. Then, Lordship, another factor which came in was a PIL which was filed in 2002 in the Supreme Court in Balak Krishnan's case, where the Supreme Court is monitoring the wetlands because there is a big clash going on between the central government and the state government because the land and water is within the competence of the state. And the inventory which has to be made under the Central Wetland Act by monitoring in the Supreme Court in the Bala Subramaniam's case, the Supreme Court in 2017 specifically passed that the wetlands are not being protected because once the wetlands are not protected, we are a signatory to the international conference in the Sharm el-Sheikh and all the international Paris onwards, the water security part is there. So what had happened, Supreme Court has said that the 25 high courts throughout the country will act as a regulator and they will monitor their sites in their states. Ramsar site is for Assam. And in fact, Lordship, there's another PL which was also disposed of, which I have annexed at the last part. PIL Somoto, which was taken up by this Division Bench 3 of 2017 at page 372. There also, the High Court, the Division Bench has passed a slew of orders, directions, and your Lordship will find at 378, the following directions were issued because everything goes in tandem. At 378, can I read?
Yes.
The respondent authorities shall protect the area of deeper bill and shall adhere to the statements made in the affidavit for protecting the said wetlands. The respondent state is hereby directed to see that the solid waste management plan under construction will be fully commissioned by 1st July 2023. Now, at this stage, I am coming because I am bringing in two very important issues. I don't come within the purview of the tribunal for a simple reason. The Wildlife Act, the Deepor Bill, the wildlife sanctuary part, the elephant corridor protection is also one of. And the Lordship, under the National Tribunals Act, the wildlife protection has been within the purview of the High Court. All 7 acts are within the purview of the tribunal. Wildlife has been kept. I'm coming for that protection. I want 3 protection. A notice may be issued. I want a monitoring. The latest, there was a meeting because the government has also taken sincere steps to see that this Deepor Bill is protected because
we know we are taking up another matter.
Yes.
When the stand of the government was very clear.
Yes, very clear. Yes. But one thing I want to know that June of 2022, a meeting was held regarding they are trying to doubly electrify the railway tracks because one of the grievances were if you shift it to the northern part, the Wildlife Institute had given independent report. The entire attack on the wildlife will be, but this was being done at an earlier part. The railways have also stated that we are trying to build in underpasses and certain ducts or whatever. But I want that a monitoring committee of the Chief Secretary is looking into the matter. I want that a notice may go and the progress report be placed. That is my simple submission.
Very well. Dismiss, we'll put you to notice and so also the central government.
Yes.
This is in the interest of everyone.
Everyone.
Every citizen of
yes.
Assam, for that matter, for the country.
Yes.
issue
And
notice.
only regarding the prayer number 3, the present project is going on there.
Solid waste.
Something at Ballotol. It is in terms of the honorable court's order.
Likely to be completed by July.
No, it is going on. We gave a commitment that by March, then we prayed that another 2 months may be given to us.
Okay.
Only one submission. I fully agree with the submission of the learned advocate general. My information is that there was a direction for moving the decentralization of the manure part which they make from the waste. That also should be speeded up, because if that is done, the lake is protected.
That's true.
Because dumping is going on.
Yes. Issue notice to the respondents. Learned Advocate General Mr. Saikia puts in appearance on behalf of the respondents numbers. Four, five. 4, 5 and 8 even. GMC. No.
GMC, yes, Lordship.
4, 5, 8, 9. 10, GMDA.
Yes, Lordship.
10, 11.
11, State Board of, yes, Lordship, I can appear.
And 15. 15, 16.
15 and 16, yes, Lordship.
Pollution Control Board. It
And
must be a
18
standing
also.
council.
18
Mr.
also.
So and so puts in appearance on behalf of this part. 18 also. Mr. AG will appear for the 18 also. Pollution Control Board, you provide notice to Mr. So and so. You are. Mr. So and so puts in appearance on behalf of the responsibles. 2, 12 and 14. Railways. Okay. For 1 and 3. So and so puts in appearance on behalf of the responsibles. 1 and 3. Thus, process be issued to the response numbers 6 and 7 also, Mr. AG will be appearing.
Yes, Lordship, up
Yes.
to and 17 also.
6, 7, 17. So. All right, services come.
Central
Complete.
Wetland Regulatory Authority. Represented by the BCCF and HOP Assam.
Yes, the service is complete. Sufficient copies of the paper book be provided to learned counsel representing the respondents who pay for and are granted 4 weeks time to place on record their response to this PIL involving issues of great importance pertaining to the preservation of the V4B.
No, highly obliged.
Only one thing, the respondent number 5, since he was the chairman, the chief secretary is the chairman, the status report may also be called on the next.
The status report, latest status report
Lordship, is
of
the affidavit
projects
will annex.
being undertaken in pursuance of the earlier directions given by this
Yes.
court as well as the NGT
NGT.
be placed on record by the next date of hearing.
Okay.
Item number 3.
In the second case,
We are taking it up Thursday, 27th April.
Malad, in the second case, what has happened? The order, Malad, this was against the.
You are in item number 3.
Yes, Lordship, it has come up for orders, but just the factual part, I'd like to say on 17/12/2021, the
Yes.
division bench of the Guwahati High Court had issued an interim order. Malad, what has happened? This was against in the Dipru Saikwa National Park. Drilling was being proposed to be done by Oil India, and we came in that there was an undertaking given by Oil India in 2017 before the Supreme Court that before we go for the drilling, we will have to obtain biodiversity impact assessment report. That was not done, and we, practicing advocate of the Guwahati High Court, Mr. Khatania, and another person filed this case, and we could convince the court that since that was not done, a fragile zone will now be affected by oil, and an interim order was passed on. And Lordship, the response, all the respondents have given their thing. Today it has come up basically for, since the pleadings are complete, I am ready for the hearing of the matter.
Kindly please the last order passed by your Lordship, 17/12/2021.
17/12.
Identical cases are filed before Honorable Supreme Tribunal and Honorable Supreme Court. There are 2 cases before the Honorable Supreme Court. One has been decided, one is pending.
17/12/2021, second paragraph, my lord. Second paragraph, Mr. Sharma, learned standing council, oil submits that similar matter, more particularly pertaining to challenge to the notification dated 6 so and so. Wherever the Minister of Environment, Forest and Climate Change made an amendment to the
And
amendment.
that petition is still pending.
Yes, pending, my lord.
So we will await the outcome of that petition.
Yes.
In fact, this argument was made on.
And regarding, my lord, this is one of the prayer, this is one of the challenge.
Yes.
The other challenge, my lord, and there are the proceeding before the NGD, and that was went up to honorable Apex Code framing certain guidelines. They sent it back to the honorable Green Tribunal, and Green Tribunal has decided on 10th of March, my lord.
Well, that-
Only this prayer remains, my lord.
Malad, I'd like to clarify here. Two issues come up. The tribunal part, I'm no way affected because that is regarding the compensation. I have come here against the action of the respondent government, central government, to give a retrospective effect by removing the public hearing part, because public hearing is a democratic process. Honorable Present Chief Justice, there is a very landmark judgment from Himachal Pradesh, where and in the airport case of Goa, where the Supreme Court has said it's a democratic process. When you go for a project, you have to hear them. And in fact, it has been reiterated in the Lafarge case from Meghalaya also. So Lordship will await for it because the interim protection protects.
Is already
forest.
there.
Precisely, that is under challenge before honorable Supreme Court.
Okay.
No problem.
The matter is deferred by 8 weeks, awaiting decision of writ petition WPC number 835/2020. Pending before honorable Supreme Court. Matters are deferred.
Well, the interim order passed.
Interim order passed earlier shall continue.
Apply.
Matter is, this is only one pay.
Apply.
Item number 4.
Yeah, that's fine, yes.
My lord, before I argue, my lord, I may be fair, my lord, that there was earlier one PIL before this coordinate bench. I've given the copy, my lord. In that coordinate bench, my lord, the issue was regarding the larger issue of the, my lord, the scheme.
Of?
Scheme regarding the, my lord, scheme of the irrigation scheme, my lord. This was actually decided, my lord. And thereafter it was, my lord, by order dated 8/3/22, my lord.
Yes.
Since, my lord, the principles of res judicata was stated, my lord, then it was referred back to the, my lord, principal secretary of the council to look into the grievance of the petitioner, if they have any materials, and to pass appropriate order. So in that humble submission, this may also be disposed of, my lord, since it is pending long, my lord. And I may be allowed to approach the, my lord, principal secretary and see him. Karyang long, my lord.
What do you say, sir?
My lord, earlier, my lord, round, my learned friend was the counsel of that petition, also PIL, and that has been disposed of. And we have already annexed the documents that we have completed the project. If he has anything to say about that, he can approach the principal secretary of Karbi Anglong Autonomous Council.
Mr. Borwan, learned counsel for the petitioner has fairly submitted that the subject matter in this petition pertains to complaints as regards implementation of the various schemes under the irrigation department of the KSC area. KSC, however, because of the same issue having been already gone into and having been considered by this court in PIL 37 of 2019. This matter does not survive for consideration of this court. As such, Mr. Borua seeks disposal of the writ petition in the light of the order dated so and so, the order dated 8/3/2022, passed in PIL 37 of 2019, by granting his client the liberty to approach the appropriate authority, raising grievance, if any. Mr. J. Chutia Leonard, standing counsel KSC, is present and does not have any objection. The prayer is allowed. In view of the above, this resolution stands, this PIL stands disposed of in terms of the obligation.
Item number 5.
Others.
Representation. Mark the attendance of all lawyers.
It's an additional, I have not got it here. March, 3rd March.
Hey, please, Lordship.
Affidavit.
No, this,
Second February. After that, there is nothing. 22nd, right? No, well on choice has been tagged. It's just the office noting of 4 months. It's not
You have to repeat name.
name will up. 124. Page 124. Last one. Their stand is that it is in a Patashur land. The mining is taking place. Seventeen, 12, 24, 131. Therefore, 20, 12, 11. Is 131, which we can put it. It's a fact finding report. कुछ भी नहीं है, there's nothing else. So let us see what Mr. Das says. Which was 20th April report. 8th April 26th.
The reports 17/12/2022 and 2023 says there is no more.
There is no, yes, my lord, there is no more illegal mining going on. My lord, that is one aspect of the matter. Lord, this honorable court has taken good care of that, my lord. There is another aspect, perhaps that has not been gone into. In the letter written by late senior advocate Mr. Nila Datta, there is another angle, that is encroachment, illegal encroachment of this particular heritage site by the tea estates. That is also another issue. Perhaps that issue has not been looked into till now, because we are, since beginning, we are concentrating on this illegal mining going on. But if your lordships kindly take the letter written by the senior counsel, it says the news item itself self-explanatory and indicates serious illegal encroachment of the heritage site of Chowlung Sukafa, the father figure of Ahom kingdom, by tea states, enabling coal smiling by illegal mining of coal in the entire Tipam area. So for conservation of this heritage site, perhaps that also be looked into, subject to, my lord, what your lordships.
You're reading from the letter.
I am reading from the letter written by 5/4/2018. Yes, my lord. I am forwarding herewith a newspaper report dated so and so published. Yes, my lord. My lord, till date, perhaps I have checked up the records, my lord. We are concentrating
on them to submit a practical report regarding that.
By the revenue authorities.
A vague kind of assertion, even in the newspaper report, It has been, point out whether this fact is placed. Indicated, please read.
I'm just, yes, madam.
Translation of.
Yes, my lord, there is mention about that.
Encroachments by section of.
Third line,
Business.
yes, my lord.
Has destroyed the heritage of.
Yes, third line. There is mention about this aspect of the matter.
Each second. Translation of. Yeah.
Mr. Pathak, give us a report on this allegation of encroachment.
Encroachments on the tip of hill.
Very well, your lordship. I'll get a report from the revenue authorities and what is the present
Get a
status?
proper physical verification done
Very well,
with the revenue records.
very well.
And we may direct senior officer of the revenue department to
Very-
conduct a physical verification.
Very-
Commissioner? No.
All right.
The revenue to this
Lordship, my learned friend is.
Last occasion, lordship, exactly not this, what has been stated today, lordship, but they're alleging about the rat holes and illegal mining and all this, lordship. And on this, I requested the deputy commissioner.
That
Yes.
evidence report states in addition thereto, the newspaper report reads encroachment by tea plantation businessmen.
Tea plantation, lordship, there are the
Estates.
periodic
Estates.
patal and lordship, I have the report if your lordship can kindly go through. Yes, this is of 23rd February by the deputy commissioner Tinsukia lordship.
This is again the same report. We have read that. We have read that report. But the issue is whether any physical verification of the people mill for finding out encroachments, not in relation to mining, other encroachments.
Lordship.
Get that physically verified by the VC.
Mr. Transfer appearance report, then you write. Taking note of a report appearing in the Assamese newspaper Niyamiya Bhatta pertaining to the illegal mining going on in the Tipam, historic Tipam field, as well as the incidents of encroachment of the Tipam hill area. Sri Nilay, late Nilay Datta, senior advocate, had written a letter inviting the attention of this court based on which PIL bracket so motor bracket 03 of 2018 was registered and reports were called for from the concerned authorities. We find that there are reports dated 17/12/2022 and 20/2/2022 submitted by the concerned jurisdictional divisional forest officer, a perusal of which goes to show that the incidents of illegal mining has since been stopped due to the intervention of the departmental authorities. First up, what is however not clear, however, not clear from the materials on record as to whether any action has been taken by the district administration of the revenue authorities pertaining to the allegation of encroachment of Tipam Hill. First up, Ms. M. Bhattacharjee, learned additional senior government advocate, Assam Praise Court, and is granted to obtain a report from the revenue authorities of the district on the allegation of encroachment of Tipam Hill land and place the same before this court. Let this matter be listed accordingly.
EPF.